Hello everyone, Mahima Goyal this side from Dewan and Chopra. Today we are discussing the compounding versus adjudication under the Companies Act 2013. Under the Companies Act 2013, not every default lands you in a criminal court. Depending on the nature of the offence, a company has two different routes to resolve it: compounding and adjudication. Now, let's break down how these two mechanisms differ and when each one applies. Let's start with the compounding, which is governed by Section 441 of the Companies Act 2013. So, compounding applies to offences that are punishable with fine only or with fine or imprisonment, but importantly, it does not apply where the imprisonment is mandatory or where the imprisonment is coupled with as an and not an or. However, offences punishable with imprisonment only or imprisonment and fine are not compoundable. Here, how it's work. The company or officer in default voluntarily applies to compound the offence either before the prosecution is launched or even after it's initiated, but before the judgment is pronounced. The forum for deciding the compounding depends on the quantum. If the maximum fine involved is up to Rs 25 lakh, the application goes to the regional director. Beyond that, it goes to the National Company Law Tribunal. The key outcome here is that once compounded, the offence is treated as settled, the applicant gets the immunity from prosecution and no further criminal proceedings can be initiated or continued for the same offence. It's essentially a settlement mechanism, a quick closure without going through a full criminal trial. One important key point here is that compounding cannot be availed if the similar offence was already compounded within the preceding 3 years. Now, next part is adjudication, which governs under Section 454 of the Companies Act 2013. This mechanism came into sharper focus after the decriminalization push first in 2018 and expanded significantly in 2020, where many technical and procedural defaults were converted from criminal offence into the civil penalty. Here, the Registrar of Companies is appointed as the adjudicating officer. Now, unlike compounding, adjudication is traditionally seen as ROC-driven, initiated suo motu by the registrar or on a reference when a default under specific penalty provision is noticed. But in practice, there is a growing trend of companies themselves filing suo motu application, which means the company voluntarily approaches a registrar of companies once it identifies a default rather than waiting to be caught. This is increasingly common for defaults like delayed filings, non-compliance with disclosure requirements, or procedural lapses, where the company wants to proactively regularize the default, gets the penalty determined, and close the matter rather than let it linger as an open compliance risk. Once triggered, whether by the ROC or by the company itself, the process is the same. The adjudicating officer issues a notice, hears the complaint officer in default, and passes an order imposing a monetary penalty as prescribed under the relevant section. So here, the key distinction between the adjudication and compounding is as follows. 1. Nature of offence. Compounding applies to fine or imprisonment offences, whereas adjudication applies to purely penalty provisions. Second, compounding is always voluntarily initiated by the company. Adjudication can be initiated either by the registrar suo motu or increasingly by the companies themselves filing a suo motu application to proactively regularize a default. Third, compounding goes to the regional director or National Company Law Tribunal depending upon the quantum of the fine involved. Adjudication starts at the Registrar of Company level. Fourth, compounding gives the immunity from the prosecution. Adjudication results in a penalty order with no criminal involved. Both mechanisms serve the same larger objective, encouraging the voluntarily compliance and reducing the burden on the criminal courts for default that don't warrant it. Understanding which pathway applies to a given default is critical for effective corporate compliance strategy. Thank you for watching.